This video will give you a short and very basic introduction to the codification of the law in Germany. Here is a map showing you Europe in the early 1700s. It is difficult to identify Germany on this map. Look at the white in the middle of the picture. It gives you an indication that the country was not unified back then, but was a mosaic of somehow independent states that were, however, structured in an empire. But the emperor didn't have very strong powers in the various parts of Germany. Germany has been a part of Europe that had been very receptive to the jus commune that I have discussed in other videos and in other parts of the course. Remember that the jus commune was a combination of Roman law, canon law, and customs that were generally accepted in European countries that had been part of the Roman Empire, had received Roman influence, and were Christian countries. Unlike France, that developed as a rather independent country and developed its own legal tradition, Germany was a little bit like Italy and kept the Roman tradition alive. And probably in Germany, Roman law was far more influential than custom. Custom could be described as being interstitial. It would only be applied if existing. So this is a typical situation that we have described earlier in Italy and in some parts of Europe. If local legislation existed, it would be applied. In the absence of such legislation, and if there was no strong custom to apply in the land, jurists, administrators would resort to Roman law, canon law, and would apply the jus commune. Germany is also known as part of the world where the development of natural law philosophy has had a strong impact, particularly in the 18th century, with scholars like Grotius and Pufendorf, who have been contributing to the development of the law of nations, the ancestor of international laws. These people believed that law was based on reason and that human being had to use their mind and produce rational solutions for legal problems. And they were very much relying on broad and general principles. You see in Germany that a number of school of thoughts developed. I just alluded to natural law, connecting with the law of reason, rationalism, and developed at the time on the Enlightenment, in the 18th century. But Germany has been also the seat of a very powerful historical school, an approach of the law that views the law as being historically determined, as being a product of society and civilization. And the Germans like to talk about the Volksgeist. Okay, you've got to follow the usage of the people, the thinking of the people. This historical school has been very, very influential in Germany and has been conflicting somehow with another school of thought called the Pandectic school. You may remember, if you viewed my other videos, and of course, if you are in my legal traditions class, that the Pondex was the encyclopedic part of the Corpus Juris Civilis made at the time of Justinian. And scholars over the century, I mean, from the 12th century onwards, have developed science and publications over the Pondex. And German scholars developed very dogmatic views. There was this idea that by pure logic, one should be able to guess what legal solution to a particular problem would be. And building on the concepts and the categories that had been developed from Roman law, uh, they built a system that became more and more abstract. They were trying to find categories and subcategories that could cover any aspect of social reality. So you see that you have thinkers who rather go with the law of reason and uh, natural law, which is really the child of the Enlightenment. You have this historical school that sees the law as a continuum, the fruit of slow social evolution, which may accelerate at times, like particularly at the time of the Industrial Revolution, and the Pandectic school that is pushing the law towards abstraction and very refined categorization. All this to make you understand that a basic feature of German law or law in Germany, it's a law that is largely driven by the law professors. How that? That's kind of strange to see professors or university to be the driving force of the development of the legal system. There are historical reasons for that. Do not forget that Germany was not unified, right? It's a mosaic of states, more or less sovereign. And each of these jurisdictions had its highest court. And when these courts were facing new problems or complicated problems, the traditional approach was to ask for the opinion of the doctors, the opinio communis doctorum, the common opinion of the doctors, with the idea that if law professors agreed that this was supposed to be the law, then these courts would follow the teaching of the leading professors. If there was too much division, they would have to make a choice. But when there was really a stream of thought, they would heavily rely on the position of the doctor, which explains that at the end of the day, though Germany was divided into Kingdom of Bavaria, Kingdom of Prussia, of Saxony, etc., yet you have a fair homogeneity of the law all over the country because of this tradition to follow the law of the professors, which indicates that it has been, in many respects, easier to unify German law by way of codification than it has been in France, where you had multiple legal traditions following Roman law in the south and more customary law patterns in the north. The first big attempt, or at least one attempt of codifying the law that is remembered by historians and comparativists, because there have been a few others, is the Prussian Code that was enacted in 1794. So at the end, the very end of the 18th century. Its official name is Allgemeine Landrecht für die preußische Staaten of Germany. So the general law for the states of Prussia. Frederick II, who was King of Prussia, was behind the enactment of this code. It's largely inspired by the natural school of law, but it borrows also to the other schools. historical school and to maybe a lesser extent the Pandects. It is a code that is quite lengthy and complex. It has 17,000 articles. It's a pretty lengthy. The idea, and here you have a bit of the spirit of the Pandect, was to provide for a solution for every problem that could be anticipated. This model has not been very, very successful. The French, 10 years later, published their Code Napoleon, which has more broader rules that can be more easily adapted to the evolution of society. This code is very much rooted in the 18th century views, maybe looks a bit backwards in certain respects, especially regarding the organization of society. You have rules for the masters and you have rules for the servant. It's very reflective of a class system, something that is totally absent of the French Napoleonic code. This code could have been a model for codification of Germany once it would get unified, but this did not happen, maybe because of the complexity and too much detail in that code. A scholar who has been very influential in the period that will lead to codification in Germany is Friedrich Karl von Savigny. Savigny was an apostle of the historical school. However, his thinking was very largely influenced by the Pandect. He is sort of feeding, if you will, in both traditions. And he was certainly the lead. He's the German lawyers that everyone interested in German law would know, and he's known actually worldwide by people who have an interest in comparative law. So Savigny took a big part to the debate as to whether codification should take place in Germany as it had in France. Codification, actually, the idea of codification had reached part of Germany because you might remember that during the Napoleonic empires, parts of Germany, the west bank of the Rhine River was actually under French jurisdiction. And the French Civil Code continue applying in this part of Germany, despite the abolition of the Napoleonic Empire. And a scholar like Thibault, who was professor in Heidelberg, you remark that these people have French name, okay? They are French Huguenots who have been migrating to Germany when Catholicism tried to eliminate the Reformation in France. Thibault was a strong apostle of codification. He taught in Heidelberg. It was under the influence of the Napoleonic Code. He thought that it would facilitate the development of economy in Germany by way of unification of the law. It makes it more accessible. It gives more transparency, easier access to the legal material. It's also a vehicle for modernization of the law, what had happened in France at the time of codification. So he was very vocal and favored codification and said, well, we have to unify Germany and then we will be able to adopt a civil code for a unified Germany. Savigny was very much opposed to this idea of codification. And that's the spirit of the historical school that speaks in him in this debate. He thought that codifying the law may freeze the development of the law in time. For him, codification is just, you see, a snapshot of what the law is at the time of codification, and it might slow or hinder the natural progressive development of the law, which is very much the conception of the historical school. So he was opposing, if you will, all the arguments made by Thibault. But the idea of codification will end up to win in Germany as it has in other countries. I will make a little detour to a very significant country south of Germany, Austria. The Habsburg Empire had adopted codification not long after the French in 1811 with the General Civil Code of Austria, the Allgemeines Bürgerliches Gesetzbuch, the ABGB, as they call it in short, which is really a natural law product. It's based on the ideals of freedom, equality before the law, no class system, a very general and simple provision, a little bit in the spirit of the French Civil Code. It reflects Roman law division, just like the Napoleonic Code. So you have here a pretty accessible presentation of what I will call, in a very generic way, Germanic law, the law as it has developed in the German-speaking parts of Europe. The Germans, when they will adopt a code, won't follow the Austrian model. The Austrian model is much closer to the French than to what will become the German model of codification. But again, as I indicated earlier, a political event was necessary to permit a German codification. And that's precisely the unification of the German states. I'm not going to comment on the way this has been politically achieved. It's clear that Prussia, which was a large kingdom in the north part of Germany and the western part of Germany, as it was stretching all the way to Poland and to Russia, was the driving force of unification. And it's been, in some respects, military unification. Talk to the people in the south of Germany, where my wife is from. They don't particularly like the Prussian, and they remember that the Prussian have been waging a war against Bavaria, okay, to merge Bavaria in the new Germanic Empire. But once this unification was achieved in the early 1860s, legal minds and legal scholars started working towards a codification. Emperor William II was much in favor. The administration of the new Reich was largely in the hand of the Eisen Chancellor, the Iron Chancellor, Otto von Bismarck. And this system was a little bit authoritarian. A commission was made for producing a civil code. They did a first draft that was discussed and rejected because it was found to move a little bit too far away from the historical school. And eventually the second draft was adopted in 1896. And the Germans gave them time to study this new code before it would come into law, have the force of law on January the 1st, 1900. You will remark that there are almost 100 years between the adoption of the French Civil Code and the enactment of this new code that has been regarded from that time on as the new model, a new possibility of codifying the law. So we're not going to go into the details of the Bürgerliches Gesetzbuch. I know it's hard to remember, but BGB, just think the big German book, and that will do the trick. So if you look at the mood of this code, you'll find it that it is very socially conservative. Um, as much as the French code was progressive in many respects and was an anticipation of the 19th century, the German code is looking behind and gives the ideology and the cadence that has developed during that 19th century. Um, it is not much of an anticipation of the century that was inaugurated with its entry into force. The scholar Radbruch, Professor Radbruch, said it has more the cadence of the 19th century than the upbeat of the 20th. And it's very much a product of the German Pandectist school. The drafters wanted the code to be very exact, precise, abstract. It's not case-based. It's all based on categories, subcategories, etc. Uh, it doesn't claim to be a code made for the citizen. It's not citizen-friendly. There is no idea of educating the people, doing these things. It is a code that is made for the jurists, for the lawyers, for the expert. It's written in expert mode rather than in everybody. It's you cannot study, law 101 with a code like this. Okay, it takes to be educated already to the law and to the categories to understand how that code is working. The language is very conceptual. The Germans have a rare capacity at making very lengthy compound words, connecting words together and making words that can be one line long. And the legal language is pretty hard to understand and to manipulate. And it has been described by some scholars as a legal calculating machine. It's a little bit like a computer. You don't want to look what is inside a computer. We are lost, we don't understand what is there. The common man opening the BGB has a hard time to navigate the text and understand what it is about. And you will understand other reasons why it is like this when you look at the organization of the code. If you look at the structure, you see that it has a general part that is rather developed. I will explain in a few seconds what this general part is about. Then you have the law of obligations, law of property, family law, and the fifth book is law of succession. I give you a link, by the way, if you want to see an English translation of the German Civil Code. Now, what about this general part? What is the idea about this? The Pandectists wanted the law to cover everything, and they hated repetition. Things should be said and expressed only once in the code. Let me give you an example of something they do not like. If you look at the French Civil Code, you have a law of contracts and general rules about contracts, and you have the law about marriage. Marriage is pretty much based on an agreement between people, okay? And there are rules about consent to marry that reflect the rules that we use for consent when you are doing a business contract. Marriage is a bit more than business, right? Though there may be a business arrangement, property arrangement. The Germans thought, okay, all these rules relating to consent, okay, consent that is needed to make a contract, consent that is needed for marriage, consent that is needed for adoption, consent that is needed to make a testament, all things that are discussed in particular books of the code. Contract is in book 2, law of obligation. Marriage is in book 4, family law. Testament is in book 5, law of succession. all the rules about consent are put in the general part, which means when you are dealing with contractual relationship and you apply rules in book 2, you have to combine the rules of book 2 with the general rules that are found in book 1. The same if you are dealing with testament, you have to reconcile the rules in the general part with rules in the law of succession. It can be even more complex because contracts, you may do a contract of sale. So regarding consent, go to part 1. Regarding general rules of contract, go to the general rules of contract in law of obligation, and you will have a special chapter about sales. So you have 3 layers of rules, lots of cross references. So it takes to know the whole code, and particularly to be very familiar with what you find in the general part, to have an adequate understanding of the other parts of the code. It's a little bit like your computer. It's going and digging in different parts, in different files, etc., to give you what you want it to do. It's a little bit the same. So it is a sort of, it takes to be an expert in legal computer science, if you will, to operate with the BGB. Okay, so citizens really need the help and the assistance of lawyers. It's very different from the Civil Code of France or of Louisiana, where you can have a basic understanding for the common man, and you will only need the assistance of a lawyer if you have a complex problem and need to address or use the code at an expert level. The code, though reflecting ideas of the past, is nonetheless open to evolution. And here you find some influence of natural law in the making of the code, of the natural law approach. You have a number of open-ended provisions that we can call the general clauses in the code that help the code breathe. Otherwise, it's a little bit stuffy in there because you have to play and jungle with all these categories. I'm giving you 2 examples here. Look at paragraph 226 that is in the general part. It can be seen as a sort of prohibition of chicanery. It says that the exercise of a right is not permitted if its only purpose consists in causing damage to another. That's the idea that is known as abuse of right. The law may give you a right, but if you exert that right for the only purpose of aggravating others and causing damage to others, this is illegal. You can see that it's written in very, very general terms, and it's left to judges to make a decision using discretion, using legal literature, using jurisprudence, whether they should or should not apply that rule in a particular case. The other example that I'm going to give is paragraph 242, Treue und Glaube, the idea of good faith, if you want. And again, it's a short provision that says that an obligor or creditor, someone who has an obligation, has a duty to perform according to the requirements of good faith, taking customary practice into consideration. It's been a very important provision to help adopt the code to evolution. I will give you one example. After World War I, Germany, being defeated by the coalition of the French, the English, American, etc., found itself obliged to pay heavy compensation, particularly to the French, and the country was in economic ruin and has been experiencing extreme inflation. I'm not talking about 10 or 20% annual inflation that we get every now and then in our Western countries. We are talking about inflation by 1,000% in a very short period of time. You were going in the morning, you had enough money in your purse to buy a piece of bread. It would take in the evening to have 2 suitcases full of banknotes to buy the same commodity. And that caused big problems with contracts that had been made based on price that was completely ridiculous a few weeks, if not a few months, after the contract was made. And these contracts were legally binding. Well, German courts, using the Treuhandglaube provision, came up to conclude that it would be against good faith to um, satisfy a debt that was of a significant amount with paying an amount of money that was ridiculous and reflected maybe 0.5% of what it was worth when the contract was made. So you see that these general clauses that appear in part one of the code and in other parts of the code have been facilitating adaptation by way of judicial interpretation. And of course, like in other codified systems, revision of the code is always a possibility. And the German Civil Code has known probably its most significant revision in the year 2000 with a big reform of the law of obligation that came into force in the year 2002. Now, the last element of this brief survey of codification of the law in Germany will deal with the reunification of Germany that took place, I would say, rather recently, though you were possibly not even born when this happened. After World War II, Germany has been divided because the west of it has been liberated by the United States, Canada, France, Britain, and the east by Russia, okay, by the Soviet Russia. And with the fall of the Berlin Wall, the Glasnost, Perestroika, all the events that took place in the late 80s and early 90s, this has been leading the way to reunification of Germany. East Germany had kept, interestingly, the German code that had been adopted in 1900 as far as consistent with communism, which was applied, as a way of the organization of the economy. So legally speaking, this unification didn't cause huge problems. But actually, generally speaking, you can say that all the laws that were applied in West Germany became applicable overnight in Eastern Germany. So it's actually, some say it's more an annexation than a unification. There are only a few exceptions to that. For example, the laws regarding abortion were way more liberal in Eastern Germany than in West Germany. So East Germany was able to keep with its very liberal rules for some time until the new parliament, if you will, the new legislator, federal legislator, could build up rules that would be common to the West and the East. And of course, all this is done in compliance with federalism. Okay, Germany, I didn't mention that, but has been reorganized after World War II as a federal republic with lenders. But you see, and that is an important point, that the federal government or administration has the power to create and engineer the civil law. Okay, the civil code is made by the Bund, by the federal state, and not by the individual lenders. Individual lenders may have full jurisdiction regarding education, the transportation, and other areas. But interestingly, Germany has kept a sort of centralized view regarding the law, which does not disturb the people, because, as I told you earlier, historically, this is a part of the world where the law has always been homogeneous, created by scholars, and we have, and that would be my final word, a civil code that has been created by legal scholars for legal scholars, and lawyers in Germany have, in a way, to be able to function as legal scholars to practice the law in their country. Thank you for your attention, and I will meet you again discussing codification in Switzerland.